Welcome back to another episode of Divorce at Altitude. This is your co-host, Ryan Kalamaya. This week, I am joined by John Hoelle, and we are going to talk about the future of family law. Amy and I have frequently talked about tech and its role in our firm and some of the cutting edge issues that we deal with in terms of actually practicing law. We've also in previous episodes talked about modern trends, but this week we are going to hear from John about some issues that we've never talked about: parenting contracts and having a mission statement or values for married couples in the event that there is a divorce, and a variety of other issues. I've been looking forward to this conversation for a while, so let me tell you a little bit about our guest. John is a Boulder mediator and lawyer. He graduated from CU Law, Go Buffs, and he's the published author of a book and principal at Conscious Family. So, John, before I go on, welcome to the show.
Thanks so much, Ryan. Really glad to be here.
So, why don't you tell listeners a little bit about your background as relevant for the discussion on divorce and family law, so that we know a little bit more about you and your perspective on things.
Thanks, Ryan. Yeah, so I'm a second career attorney and went to CU Law and had no idea that I was going to go into family law. I thought maybe I'd work in policy or something like that. But came out of there and while studying for the bar, had to learn some about family law and had gone through a divorce myself. And so realized this is an area that I get this and I can help people in this area. Along the way, I had also gotten trained in the healing arts before going to law school. And I knew I wanted to bring something of that healing into my professional work. I had no idea what that meant. And getting into family law and eventually getting trained as a mediator and the collaborative approach to helping people get through divorce has really been a fulfillment of that desire to do healing work. One of my professors at CU, I remember, talked about lawyers having a sort of a sacred role as social repairers, or that's their kind of the basis of that role. And so that was a big part, I think, in directing me into wanting to do this kind of work. That's very high touch, directly impacting people's lives going through a tough time that I can resonate with.
Yeah, on your guys' website, on your bio, John, you've got a reference that people frequently ask you how you can do what you do, which is something that family law professionals, we hear all the time. And like you, I never thought that I was going to go into family law. So, but when you kind of get the bug or really see the pain and other things that are going on, and you have that spirit of trying to repair and help, I think it really kind of takes hold of you.
Totally.
So let's talk about the benefits instead of kind of harping on the pain and damage, but let's really talk about the benefits to couples and their kids in putting down values early in a marriage, and how that might be beneficial in the event that there is a divorce.
Yeah. So, one of the things that I shied away from doing a lot of was prenuptial agreements for a long time. And it wasn't until, a few years ago that we realized, okay, there are ways that our firm can help create these sort of marital contracts that is actually really supportive to the people as they're getting married. And because so often the process of navigating a prenuptial contract is a damaging one, a painful one when lawyers are involved right out of the gate, and you have one lawyer handing a draft agreement to the other party. And they're often so lopsided, and so it's something that we've been developing is what does it look like to have kind of a new paradigm sort of prenuptial agreement that really is supportive to people. And and there's a lot of it has to do with finances and making sure that whatever might be separate at the outset during the course of the marriage, that ultimately vests in the marriage, right? That's one component of it, that you're actually over time growing more together. So that's a piece of it, but the parenting contract side of it is, that's talk about the future of family law. That's really kind of like, I mean, we consider ourselves sort of a boundary pushing firm, and this is sort of like beyond almost beyond the boundaries. But it was at CU. I had the pleasure of being an articles editor on the Law Review, and I had a chance to edit a academic paper by a professor named Sarah Abramovitz. And she later sent me an article that she had prepared about really building up the argument as to why parenting contracts should be enforceable. And that's not really the case right now. It's like
Right.
the judges and courts aren't going to just take a contract that two parents sign, and just enforce it, right? It's at this point in time, these are not enforceable kind of contracts in the way that we normally think about them. But she really made such a compelling argument to me about why this is something that should change, and that when parents, when they're in a loving space, not in the middle of a divorce, not in the middle of a breakdown, put something down with clarity and precision around what it's going to look like if something happens down the road. And that really, if people who are in sound mind, when they do that, and the judges don't have to be such a gatekeeper later on. It's like, because we already have child protective services, social services. If there's real harm that's gonna come to a child, we already have safety nets there. And so really what we're doing by considering as a culture to enforce contracts that people enter into around their kids is that we're empowering people to set forth something that's like, let's say, a 50-50 parenting schedule. That might be a sort of a common thing that people might agree way ahead of time to say, hey, if anything ever happens, we agree that we're going to be 50-50 parents. Unless there's some really harmful thing going on, like there's been domestic violence or something like that, okay, we have the means to step in and avoid harm to kids if that kind of thing happens. But short of that, we should be enforcing these things. And one of the compelling reasons, I think, is because the way it is now, you have almost a two-tier system of families. It almost goes against some of our constitutional values in the country to have one class of citizens, the intact family, where there's no judge looking over everybody's shoulder about the decisions that they're making, about how they're parenting their kids. And then we have the second class of citizens that are the non-intact families, that because there's been a divorce, because the relationship has broken down, now we have this parent figure, this big brother figure of the court breathing down everybody's neck every step of the way. And I think there's really a lot of merit to that. And this idea of allowing parents to have the autonomy and authority to enter private contracts, and that the court's just going to enforce it unless there's some really clear reason not to, instead of what you have now is the default system where the judge always has to do a best interest analysis and come in and say, here's what the court thinks is in the best interest of the kids.
Yeah, I mean, there's a lot to unpack there, John, and I think that is. I have a couple follow-up or clarifications and questions. So when you describe parenting contracts, you are referencing when people are married and not thinking of a divorce in the sense that it's not immediately on the horizon. Obviously, one of your arguments of a contract is in the event of a divorce, which is one of the motivating factors from entering into this agreement in the first place. But they are not doing it with divorce on the doorstep. Is that correct?
Correct. Yep. And by the way, it could even come into play with folks who are not married, but who are unmarried parents.
Okay, so like a cohabitation agreement, but it's more of for parenting. And just so listeners are clear, what John is referencing, and we've talked about this, Amy and I have, with Jim Bailey and amongst ourselves on the premarital agreement episodes that we have, that they'll be linked in the show notes. But the history of premarital agreements is somewhat similar to what you're saying, John, in that it used to be that they were not enforceable because they were seen from a moral standpoint as motivating people for divorce, or people just were like, divorce is bad. From a public policy standpoint, divorce is bad. We don't want to have any ickiness or any agreement that it contemplates a divorce because it's almost like out of sight, out of mind. But then in the really in the 70s, there was a big movement across the country, but these agreements were seen as financial agreements that were enforceable, and hey, these aren't so bad, and actually they result in some predictability. And as far as what I hear you say, and as an aside, before I get to kind of what I think you're saying, is right now it is against public policy to have agreements that are enforceable for parenting, for child support, but they are enforceable for money. And what you are saying, as far as I understand it, or at least what you found compelling in this article, is to take that the next step. And that is, these agreements for parenting should be considered binding. But then is that fair kind of summary?
Yeah, exactly.
And one of the things I think, before we talked about on recording, was that in your first marriage, you guys didn't have kids, but that it would have been helpful if you had kids, for you to have kind of that understanding. Is that, do you want to comment a little bit on that?
Yeah, I mean, it's, in retrospect, I'm obviously happy that we didn't have kids and we didn't have to deal with that. But knowing what kind of stresses, we went through, and then certainly seeing it in my clients, it's like, it's the kind of thing where, we were amicable, but that would have been something that very easily could have brought in, and almost certainly would have brought in, a level of conflict that otherwise wasn't present, and I think that it's so, I mean, I don't know, Ryan, if you feel the same way. I see in my practice that people unconsciously put their kids in the position of being pawns, in their negotiations. Kids get used as sort of leverage against each other, even when people don't, consciously are trying to do that. And so I think that's something that this can take it off the table. If we say, because there's laws around the country that are being considered around 50-50 parenting as presumptive, right? So this is the kind of thing that even if you don't have that as a statutory scheme, that you would have parents entering into these kinds of agreements, joint decision making, 50-50 custody, right? That unless there's some really strong reason to do something else, it gives people it just takes that off the table, I think.
Well, and that was going to be my next question, and I'm glad you brought that up, and I'm wondering what your response would be to someone that would say Colorado is, and Amy and I've kind of covered this, we've referenced this several times, and I mean, the ABA has backed this up, that Colorado is generally seen as one of the most progressive states when it comes to parenting for at least fathers. I mean, there's not a legal presumption of equal parenting time or joint decision making, but you're in Boulder, and I would imagine that you see the most there's a general trend of judges enforcing equal parenting, and what you're saying is referencing other states, and that there are these regimes of a presumption of equal parenting time. So do you think that presumption would be helpful in Colorado? And if so, then, I guess, can you explain why? And does it ameliorate or address the same concerns of parenting contracts that you found compelling, or do you think that it would be helpful to go kind of a step further?
I think it would be helpful in some ways. I think the parenting contract theory does go a step further in that it really it would take that authority away from the judge, who right now is sort of has to do this best interest analysis in every case. You know, if parents agree about what's in their kid's best interest at the time of divorce, largely I think judges are going to approve it, but they still have to do this sort of from the beginning a best interest analysis, and this takes that away, and I think it would really, in theory, only give the judge the ability to say, is there some higher standard of harm, you know, going on that I have to look for, and I don't have to be doing this basic like what's right for this kid.
So
Parents already know that.
So as far as I understand, so in essence, the court would have a presumption either under the statutory regime of equal parenting time. And I know there's different, I mean, but listeners, maybe we can have an episode on at least what those are considered, but, you know, that's like the starting point, and which is similar to, not similar, but you know, I mean, John, I know you came to law later, you know, as a second career, but you know, Robin Beatty and I talked about the change in the maintenance statute, and a lot of divorce lawyers were very resistant, but the guidelines were intended to result in predictability, and there's deviation. And so can there be deviation? I guess the question then is a standard of review, and like on a parenting contract, the court would apply whatever they agree, equal parenting time, or, you know, hey, we're going to have a different schedule. And I'm going to ask you more a little bit about what those options are. But unless the children are endangered, because as you know, there's, you know, change. And one of the questions I have for you is like, you know, divorces change. It results in change in finances, lifestyle, parenting. You frequently, I'm sure, see the kind of somewhat absentee father all of a sudden step up in a divorce and become super dad. And then, you know, the wife in our hypothetical divorce clients, Eric and Melanie Wolf is like, well, where did this come from, Eric? Because if you had been this kind of present, we wouldn't have gone through a divorce, right? So, but how would that change that you see in your practice as a mediator? How would we reconcile that? And I guess a follow up, and this is kind of a rambling question, but what do you make of someone that agrees to a parenting plan or a parenting contract? I mean, I have an 8-year-old and a 6-year-old, and I mean, they have changed dramatically. Like every day I look at them, I'm like, I can't believe that I have an 8-year-old. But when you have a parenting contract, when they don't even have kids, or maybe they're like 1 or 2 years old, and all of a sudden we're talking about like 12 and 10-year-olds.
Well, yeah, I mean, as you know, I guess I tell my clients that if they're in agreement, they have the keys to the kingdom. You know, there's nothing really they can't do. But it's when they're in breakdown, you know, at the point of divorce, at the point of breakup, that they're being asked to negotiate these decisions around their kids. That's the part that ends up being so tricky. And I think that outweighs the concern that, oh, the thing we thought was going to be in their best interest, you know, at their time of their birth, and now it's not. Well, we can always agree to something different if you know,
right.
But if we're fighting, I'm not going to trust that you're actually making the right decisions more than you made even, you know, when the kids were 0.
That's interesting. I appreciate that, because I mean, one of the observations that we make for, Eric Wolf is that if he's a sophisticated businessman, he has never been in a negotiation like he's about to embark on with his wife, who he's sideways with, because he is stuck in that negotiation and they're not getting along. There's a reason for a divorce, and I mean, you have it on your website. I mean, the litigation system, the adversarial system, is contrary just as a fundamental matter to children. And because it poses a father and a mother, or, same-sex couples, parents, against each other. And that is not, fundamentally, it's not good.
No, absolutely. I mean, that's why we're so focused as we are on trying to keep people out of that process. And probably one of the biggest questions I have when clients come in and they're interested in mediation, or they've heard about it, but they think, oh, we're in conflict. There's a level of distrust. There's a level of anger. Hey, no surprise. You're getting a divorce. These things are pretty common. Does that mean you can't mediate? Not at all. It's like, and it's almost like a little bit of magic, because when they come and they sit in my office and they sort of look to me like, can we get through this even with this level of conflict? And I look at them and I say, yeah, you can. And it's like, just by saying it, it's like I'm knighting them. Like, yes, you are able to collaborate. You are able to, work through these tough conversations. Not that they're not sweaty conversations, and the devil's in the details. And sometimes it can be challenging to get through. But, the one of the things that I live for is folks coming through that process, and they don't even have to come back to mediation later on when they have conflict down the road, because they've learned the skills to work through tough issues together. Again, I'm mostly talking about parents here, right? Like, they're going to have ongoing things that they're going to have disagreements about as their kids get older, but they've now learned they can get through those conversations, and they don't even have to come back to mediation, because they have a felt experience of we can get through this.
So could you talk maybe about the future of family law as it relates to mediation? What are the things that you think are the future of mediation? And then we'll get into lawyers fulfilling their role as social repairers next. But what are the things maybe differently that you foresee in the future, or that your firm is doing, that you don't think normal traditional mediation? And just so people understand, most of the time mediation, I know you said pro se, people that don't have lawyers, and maybe they do have lawyers, but they go into mediation. There's a neutral third party, a mediator like John, and you do shuttle diplomacy. You go from one room to the other, or you might have people in the same conference room, and when things start getting heated, then you kind of say, all right, go to your respective corners. To kind of use the boxing metaphor, which is contrary to the spirit of what you're talking about. But, can you talk about maybe the future of family law, specifically as it relates to mediation?
Yeah, I mean, I think that one of the key things there is practitioners being more comfortable, really empowering their clients to direct their own story. And I think as lawyers, we're trained to spar. We're trained to advocate, and maybe not all of us coming out of law school have the sort of native orientation around being a neutral mediator. But those of us that do, I think, to that social repairer role, I think not that advocacy is going anywhere or should go anywhere. There's absolutely a need for it and a place for it. But those of us who can function in happily in that neutral role, I think can help people really author their own destinies in a way, anchoring around what their goals are. And that may not have anything to do with the law, right? And they have to understand enough about the legal landscape, which is why I think lawyer mediators can do such a good service, especially in the area of family law, because you have to be able to navigate the landscape, navigate a system that includes legal disentanglements, right? Legal entanglements and legal disentanglements. But families have their they have their own goals and their own interests, and it's a system. It's mom, dad, or two moms, two dads, whatever, and kids. They all have their different goals, their different needs, and the law isn't, is a one size fits all kind of a thing. But I think what we try to do, and I think the future of this space is really starting from, what are the goals and what are the values for these people and for this system, and trying to architect the best outcomes from that point of view, and then translating it and making it work within the legal structure that you need to follow to process the case with the court.
Well, let's get granular, or at least like talk about specifics. So when you talk about the future of family law with mediation, do you think that bringing in experts such as like divorce planners or counselors or mental health professionals, how can you maybe talk about that? And because I don't think that is as common. And I mean, we talked about before the show collaborative law, and that was it's a term of art. It was started in the history, and it's a whole separate other episode. But that you foresee, correct me if I'm wrong, the future of family law incorporating some of those elements. So could you maybe talk about how that relates to the mediation and what you've already covered?
Sure. Yeah. No, I mean, I think I was trained in the collaborative model. I think it has a lot going for it in terms of the, it's a new paradigm of the way lawyers are thinking about what they're doing as helping people to collaborate and arrive at settlements out of court. But I think if the collaborative law process, as kind of a formal process, I think if that were like a real game changer, it would have taken over the industry by now, and it just hasn't. And I think so that's why I think lawyer mediators right now represent the best of the future, right? But taking some of those principles from the collaborative law process, as we were talking about earlier, the team approach, but really putting together the team only as appropriate. So, if one lawyer mediator can help two parties navigate the process, great, that's the only team you need. But in a lot of our cases, we absolutely are bringing on other team members, most frequently a financial expert. So like a certified divorce financial analyst, sometimes even a full CPA, or a CVA, somebody who can do business valuations, might be a really important part of the team as another neutral party. That's really where we try to utilize, one professional to come in and be able to neutrally kind of consult and help people navigate the process. Maybe it's a child expert to help people, somebody who understands the custody evaluation landscape, but isn't doing an evaluation. They're coming in to help the parents, maybe even as a therapist to the children, to help them navigate these tough issues. So I think a team approach is part of this future, but as needed.
Right. Well, and that brings to mind as we record this, in the most recent Colorado Lawyer, there was a article by a business valuation expert kind of calling out the Colorado court, in particular the Court of Appeals and Colorado Supreme Court, because there's so much uncertainty about business valuations, and really asking for some predictability. And what I hear you say is we have a lot of flexibility in family law, whether it be there's a mental health issue, there's a business valuation issue, there's certain, and the system as a whole is flexible enough to address those. And there are cases that are not appropriate for collaborative law. There's cases where the people are going to argue, and we have the optionality for those different systems. But what I hear you're saying is the majority, there's an underserved majority of people in Colorado looking at divorce that could proceed forward in a much more efficient manner with an attorney mediator that may be augmented by a valuation expert or a custody, evaluator, and that you see that as the future of family law.
Yeah, just a much more kind of tailored process for people. And by the way, that team can include advocates, right? Legal advocates. If the issues are complex enough that and one or both parties maybe needs more consultation just for them, that goes maybe out beyond the scope, right, of what a lawyer mediator can do. And a lawyer mediator has to be careful that they don't fall into the trap of giving legal advice, right, to one side, trying to helping one person maximize his or her legal position. That's definitely going beyond the bound, right? But sometimes that's important, and so we're making those recommendations. Hey, I think you each should get some consultation either during the mediation process or at minimum at the end, right? Here's the legal agreements that you're considering signing. These are important legal agreements.
Right.
Maybe you should get this reviewed.
Yeah, the unbundled or limited scope, we do that a fair amount. Amy was she was intimately involved in that process, and now she's kind of at the forefront of the paraprofessional legal program for giving people that guidance. And I think that what you are talking about, John, really strikes a chord with what Amy and I are trying to do, and me in particular, in terms of that there's a lot of need. I'm not worried as a litigator. I mean, that's primarily what I do, but I'm not worried about job security, because there are going to unfortunately be people that are going to disagree, and that is at least what I do. But there's also a role, and it's one of the reasons that we have this podcast, is to provide zero cost advice and angles, and to really push people to think about. And I appreciate and commend what you guys are doing there. So can you tell people a little bit more about your firm, and if especially people in Boulder and Denver? We were talking offline, I have a big Boulder divorce going on right now. So for people that want to find out more about you guys, can you tell listeners about your firm and where they can find more information about you?
Oh, for sure. So yeah, we're Conscious Family Law and Mediation. So you can find us at consciousfamilylaw.com. It's a spelling test, so you got to be able to spell conscious. But yeah, there's currently we have 4 lawyers working at the firm. All of us do the kind of mediation I'm talking about. We focus on mediating for folks who don't have other professional advisors independently. So we're not doing as much of the attorney-assisted mediation. We really focus on the folks who would otherwise be trying to maybe do it on their own. I tell people that when I was getting my divorce in California, I thought I could do it with the court forms, and I'm a smart guy. This was before I was a lawyer, but I took one look at it. I was like, you got to be kidding me! I can't do this on my own. I was able to find a firm somewhat like ours to help, but so yeah. We are in Boulder. We do serve folks around the state, because mediation can be accomplished very easily using Zoom or other teleconference platforms, and we don't have to. As mediators, we can't actually file anything on people's behalf. So we're not appearing in court on anybody's behalf. So we do support folks statewide, but we're born and raised in Boulder. We opened our doors in 2014. And have really been focused on this. I think we're a little bit unique as a law firm that's really focused on this mediation side of things. We have recently expanded into doing estate planning too. So especially for folks who are coming through doing a divorce, and then coming out of that may need to revisit their estate planning.
And you guys do relationship mediation or some other alternative, kind of more futuristic, progressive services. So can you maybe comment on that?
Yeah, we can't sort of help ourselves from trying to just innovate and do different things. So yeah, I did go to Brookline, Massachusetts to get trained in using mediation specifically to help folks who are trying to stay together, because it's a little bit of it's different than the legal dispute resolution,
right.
A technique. And so yeah, we call that relationship mediation when folks are trying to explore how to stay together And so, the mediation there is looking at what kinds of arrangements make sense, right, informally. So it's not coming out usually with a legal agreement, some kind of binding contract. It's coming out with informal arrangements on how do we live in the house together? How do we, arrange for finances? How do we talk to each other? How do we not talk to each other? Sometimes then that'll pivot into it can turn into a legal contract, like in the form of a postnuptial agreement, right? So a lot of
Got it.
people know about prenups, but you can have a marital contract that helps people feel safe to stay in the contract of marriage, but maybe set forth some specific things like, okay, one spouse wants to open a business or start a business. Okay, well, you can use 5 or 10,000 of our marital money towards that, but hey, if we get divorced, that's coming out of your side. Something like that. Something that can help somebody stay safe while they're trying to work to stay within the marriage.
Well, as listeners know, I mean, Amy and I describe Kalamaya Goscha as an innovative and ambitious law firm that pushes the boundaries to discover new frontiers in family law, personal injury, and criminal defense. And John, you guys are definitely on the same path. You are discovering new frontiers, and kudos to you for trying to do that social repairing that is unfortunately much needed out there. But really appreciate the time, enjoyed the conversation, and I'm interested. I think we can maybe circle back on this episode and see where things stand on parenting contracts or some of the other new developments. So look forward to continuing this conversation.
Would love that. Yeah. Thanks so much, Ryan, for having me on.
Appreciate it. Well, until next time, thank you for joining us on Divorce at Altitude. If you found this episode helpful, feel free to leave us a review, and more importantly, tell a friend about what you heard, and hopefully John's advice and insight might be helpful for you or somebody else. So appreciate the time. Thank you.